Now I have the pleasure of giving a brief introduction to the next speaker. Ms. Swasthika Arulingam is a Sri Lankan human rights lawyer and a women's rights, human rights and political activist. She also serves as a prominent member of the Liberation Movement. On 30th July 2021, she became the first female member to participate in the National Labour Advisory Council meeting after being nominated by the United Federation of Labour. She was also appointed as the Deputy Secretary General of the Commercial and Industrial Workers Union. Ms. Arulingam was also involved in the peaceful protest since its inception in the March 2022 as a volunteer representative and ardently advocated for the rights of the peaceful protesters. Without any further ado, let me now invite Ms. Swasthika Arulingam, attorney at law and women's rights activist, to share her thoughts on the topic, impacts of economic procession on the labour class.
Mr. Chairman, members of the Commission, and distinguished guests, I thought I'll use my time to perhaps forward some ideas to the Human Rights Commission because I don't get many chances like this. The International Women's Day has as we all know, has a very revolutionary past. In 1970, a group of workers in Russia came to the streets and they started protesting against war, for the rights, for food, and that propelled the Russian Revolution afterwards. So it has a very revolutionary past. But today in Sri Lanka, if you see Sri Lanka and you take the free trade zones, it's very hard to get women to protest in the free trade zones. And that's not because women don't know to protest or women are scared or any of that. Women don't come forward to protest because in the free trade zone, we don't have, when I say we, I'm also the president of a trade union. So we don't have the right to form unions. We don't have the right of association in the free trade zones of Sri Lanka. So because of that, since 1978, union rights are heavily restricted within the free trade zones. Inside the free trade zones, unions are not allowed. And after 40 years, there is only one collective agreement in the free trade zones. So therefore, we don't have rights of union rights, freedom of association, freedom of assembly, freedom of expression, in a sector which our country's economy entirely runs on. Now, why I'm emphasizing on this, keep on emphasizing on this issue is that I heard Chamila Tushari speaking about the conditions of the garment workers today and how the crisis is affecting the garment workers, how garment workers, and then I also heard Ms. Chandralekha speaking about the situation in the plantation, how workers are not eating, children are suffering from malnutrition, workers are dropping out of work because of manpower work and them not having permanent employment. So there are a severe situation in the free trade zones of Sri Lanka. Because I'm also a lawyer and because I'm also a trade unionist, I'm in a position to see what the law advocates on the one side, but also what happens on the ground. So if you take our constitution, it's a fundamental right to form and join a trade union. Freedom of association is a fundamental right. In the law, we have in the in the trade union ordinance, we have the right to form a trade union. And then in the Industrial Disputes Act, it makes it an offense to break a trade union. So on book, the law is well protected in terms of the right to form and join a trade union. And if you break a trade union, then you will be punished. The company will be punished. Now that is the law. But despite this being the law for the last 40 years, why isn't it possible for workers to form unions? And when you listen to the public opinion, or when you listen to the media, or when you listen to companies, for instance, they would tell you that the reason why people, and particularly women, and I don't have to say women because in the garment sector, majority are women, so I don't want to say women, because garment sector workers are women, plantation workers are women. So when you speak to companies, they would tell you Workers do not want to join trade unions because they don't like trade unions. Companies are giving all their rights. Unions are politicized, so workers are not interested in being politicized. And they don't want to join trade unions. That's what the companies will tell us. But after working in the free trade zone for 10 years, Ms. Chamila Tushari, more than that, she would have worked for more than 2 decades in the garment sector. We will tell you that is not the reason why women don't join trade unions. The reason is, the moment you join a trade union, you are dismissed from work. Even yesterday, I was at an unfair labor practice case in the labor tribunal, giving evidence for a case where 16 workers were dismissed simply for joining a trade union. And that is not the only case since 1978. That is the norm. Workers are dismissed when you join a trade union, you are dismissed simply because you join a trade union. So why is it that in the law you have all these rights protected and on the ground you find workers being dismissed? When you take an unfair labor practice case to court, when you take it to the labor department, or when you file a labor tribunal case, it takes almost 7 years. When you count appeals and so on, it takes almost 7 years, a minimum of 7 years, for that case to finish. Now, I being a lawyer, even I in today's economic context cannot survive more than 2 months without a salary. A garment worker gets an average salary of 26,000 rupees. A plantation worker gets a salary of 1,000 rupees. That is if she is lucky and if she plucks 20 kilograms of tea, otherwise that also she doesn't get. Migrant workers, of course, there are various other issues. I am told that the Labour Department has refused to recognize the right of migrant workers to unionize. I am told by another union. So, when a worker earns around 26,000 rupees, in this time of cost of living, she won't have any savings. And we are talking about a time when we came out of COVID and so on, so she doesn't have any savings. So, worker does not have the capacity to survive without a wage for more than a few months. So by the time the case goes and finishes in court, then the union is broken, the worker is dismissed, the worker is willing to accept any settlement, 1 million, 2 million, whatever, which is peanuts for the company, settle and completely break off the union. The reason why I emphasize on this disparity between law and the problems on the ground is there are so many issues which Chamila Tushari, I was listening to her, she was talking about. She was talking about sexual harassment of workers on the ground. She was talking about the fact that workers are not allowed to drink water. She was talking about the fact that workers they don't even have the right to be sick. If you become sick in the free trade zones, in order to get a sick leave, you need to show documentation. If there is one documentation missing, then it's deducted from your wages because you became sick. So the right to be sick is not allowed in the free trade zones. And when we speak to companies, when we speak to, let's say, officials, when we speak to brands, they would say, yes, sexual harassment, you should go and complain to police, you should take it up before the courts. We have hotlines, you can complain in the hotlines and so on. But sexual harassment is not a one-off incident in the garment sector, in the plantation. It is part and parcel of the production process. People who work in the free trade zones will tell you, harassment is part of the production process. If you speak to 20 workers, we have to give them 1 hour to tell them what kind of harassment they have been through in the previous week. So, when something is part and parcel of the production process, the only way to come out of that situation is when you give the right to workers to speak for themselves. And in Sri Lanka, the only place, the only avenue through which workers can speak for themselves, is through collective organizing inside the factory, which is denied to them. Now things are going to get worse now because I saw the Human Rights Commission also has been involved in this. There is a labour law reform which has been proposed. Now when I was being introduced, they said I was a member of the National Labour Advisory Council. I was a member for 2 years. And then my union, including 3 other unions, were removed from membership of the National Labour Advisory Council. And as a consequence of that, I am the only woman who was part of the National Labour Advisory Council, and I also was removed. And thereafter, they appointed 3 men to discuss why there are no members why there are no women in the National Labour Advisory Council. 3 men are sitting and discussing that in the National Labour Advisory Council. It has been over 1 year, and still these men have not come as to a solution as to why women are not there in the National Labour Advisory Council. And now, because one of the unions have managed to get into the National Labour Advisory Council, the minister is refusing to call the National Labour Advisory Council because the court has now instructed the minister to call into the National Labour Advisory Council. The unions he has removed arbitrarily. So now that is also not being called. But anyway, going back to the labor law reform. The minister has proposed labor law reform through a very ad hoc arbitrary process, and in the labor law reform, he's proposing things like fire and hire. He's proposing things like casual work. When you think of casual work on the ground, what's going to happen is that the semblance of protection which is given to women on the ground, for instance, maternity protection, entitlement for annual leave, and so on, is going to be removed. Casual labor is promoted as we are giving option of part-time work and so on. But on the ground, what's going to happen is that the right to maternity leave, the right to annual leave, the right of women to get into a permanent employment is completely going to be sabotaged by companies, because this is already happening illegally in the free trade zones. Free trade zone is kind of like the area where companies illegally experiment on everything which they want to see in the law in the future. So the minister is proposing fire and hire. The minister is proposing removing protections for women. The minister is now proposing that to form a union, now you need 100 members. We can't even form a union with the requirement of 7 members. Now he wants us to form a union with 100 members. So with the introduction of fire and hire as a law, what's going to happen is that even the semblance of protection women had when they join a union, if they get fired, at least they can go to the labor tribunal. Of course, it will take 7 years, but at least they can go there. Once you introduce fire and hire, what is the guarantee? There is zero guarantee. When you form a union, now you are going to get dismissed as of law. It's not even illegal anymore to dismiss someone for forming and joining a trade union. So the reason I speak about this is the Human Rights Commission is in a unique place to comment about the labor law. Unfortunately, the commentary on the labor law comes only from lawyers. And there's a problem when you only listen to lawyers when it comes to labor law. When I studied in the law college, in the first year, we learned something about labor law. There are laws like the labor laws which exist because there's an implicit recognition in the law that in society, there are some groups of people who are not equal. The employer is not equal to the employee. The employee is always in a weaker position than the employer. So the labor law looks at that implicit inequality, and what the labor law tries to do is to balance off the unequal position between the employer and the employee. Unfortunately, many lawyers today have forgotten that is the reason why labor laws exist. And they propose this idea that labor law reforms in our country are on the side of the worker. And now it should become more company friendly, otherwise investors are going to leave the country. There is a report by the Harvard University which says that's not the reason investors are not coming into the country. There's a report, a studied report saying as to why investors are not coming into the country. Labor law, the stringent or strict labor laws is not one of the reasons. But this is what our minister is proposing. And he is kind of promoting this idea in society that our labor laws are strict, our labor laws are too friendly towards the employee, and that is the reason why companies are leaving the country. So I request, when the Human Rights Commission has written a letter, I believe, to the Labour Minister, asking for the draft of the labour law. Even we have not seen the draft of the labour law. And another thing which I want to say about the draft of the labour law, it's only meant for Sinhalese speaking people in this country. There is no Tamil draft. Even I don't know what the draft of the labour law says because I don't read Sinhala. So on top of everything else, on top of all the problems which exist in the labour law draft, it is also racist because it only exists in the Sinhala language, as if the Tamil workers, as if the labour laws don't affect Tamil speaking workers in this country. So to date, we have not gotten a copy of I've written a letter to the Labour Minister, no answer to that as well. So Human Rights Commission is in a unique position to look at why labour laws exist and to look at whether the proposed labour law reforms actually are in compliance with the ILO labour standards, which it is not, and give a public opinion, which may not be binding, but this forms part of public opinion. And the other thing which I wanted to emphasize and stress is that we are in a state of deep economic crisis. Several speakers before me have emphasized on that. So I don't have to go into what is happening with the economic crisis, how it is impacting people. But one of the things our institutions, including the courts, including the government, one of the things they're doing is they're passing the entire burden of the crisis on people of this country. And people of this country did not cause this crisis. To give an example, when the IMF was pushing the government to go into debt restructuring, the first thing and the only thing the government did was to do a domestic debt restructuring. And what did the government do? Immediately went and touched on the EPF funds of workers. That is all the central bank did. They went and restructured the EPF, and the domestic debt restructuring is over. Afterwards, no talk. Private creditors are not touched. No one is looking into the money which has been stolen, nothing. Only the workers' EPF, you restructure that. Now our domestic debt problem is over. So the entire burden of the crisis, whether it be the sale of public assets, whether it be the increase of electricity hikes, the electricity tariffs, whether it be the VAT, whether it be the restructuring process, debt restructuring process, the entire burden has been put on ordinary people of this country. And in every moment, I'm hoping that institutions like the Human Rights Commission will give a public opinion, even if the court rules against us, the Supreme Court rules against us, even if the Parliament votes against the best interest of the people. I hope institutions, and in the past Human Rights Commission has done that, particularly on the anti-terror legislation. So I hope institutions like Human Rights would proactively comment on these anti-people policies which continue to be put on the people of this country. And lastly, I would like to say that the Constitution of Sri Lanka has many interesting provisions. One of the provisions is, we often ignore this chapter of the Constitution, the directive principles of state policy. And there it says that our economy should be structured in a way where the collective wealth of the society is shared amongst everyone, equitably shared amongst everyone. That is what the Constitution says. That the wealth of the society should be equitably shared amongst everyone. Unfortunately, we have been in this economic model since 1978. And while the companies make millions, even during COVID, they came and cried in the National Labour Advisory Council and saying, we are all going to shut down, please save us from this crisis and so on. While they were making millions in profits, even during the COVID crisis, they want the workers sacrifice their wages. 50% of the workers' wages were cut during the COVID crisis because the unions took a decision that we need to save the companies in order to save workers and work. We made that decision and gave that concession. But after obtaining that concession, today companies are once again going and crying and saying the labor laws are too strict, we are asked to pay too many things, we are asked to pay statutory leaves, so why don't you put it into a common fund so we don't have to pay these statutory benefits and so on. So for more than 40 years, this country has run on what the companies want us to run on. The legal system is influenced by what the companies are saying, the government is influenced by what the companies are saying, and the administrative structure, the formal structure of the state is heavily influenced by what companies want. And we have come into this crisis. So I'm hoping that from this point onwards, we will start thinking of a different economic model where redistribution becomes the center of our thought. Redistribution becomes the center of the thought. And of course, there has to be a system of income generation. Of course, there has to be a system where wealth is produced. But how is this wealth produced? And after the wealth is produced, how is it going to be redistributed in a society is something which we have to seriously think about. Thank you. Thank you so much.